Beloved Creator of all that is, we are the people on the land and soil on Oregon. We have a right to be free and self-determined, and with both of those come great responsibility. It's a responsibility that may be as much, if not more arduous than being compliant to limited living and following what is determined for us by others. But we choose that responsibility and its challenges. Mistakes may be made, yet in discernment, in valuing one's quality of life and cooperation with equally valuing the lives of others, help comes, cooperation ensues, and generosity is contagious. So with this realization, we call in our divine beloved Creator to guide us in making the best, most righteous decisions and right action. As above, so below. We are here in this abundant garden Creator has entrusted to us. We have been given the miracle of birthing children of God's children. We, as complex social beings, are here to sing and dance and experience the joy of communion, commingling, abundance, and above all, love. Let it be so, and so it is.
Thank you, Charlie.
A brief in support of the claim that bar-controlled courts are unconstitutional private bar courts. 1. Introduction. The people of Oregon assert that all courts requiring judges to be members of the Oregon Bar Association, a private association, operate as unconstitutional private bar courts, usurping judicial power vested in the people by the Oregon Constitution. This brief demonstrates that no constitutional provision authorizes bar control of the judiciary, that statutory mandates such as ORS 2.020, 2.540, and 3.050 cannot supersede the Constitution, and that such control creates a monopolistic tyranny lacking oversight by the people. Number 2. Statement of facts. The Oregon Constitution, Article 7 amended, establishes a judiciary with judges elected by the people, Section 1. Oregon Revised Statutes, ORS 2.020, 2.540, and 3.050 require that the Supreme Court, Court of Appeals, and the Circuit Court judges are all to be licensed attorneys, a condition met only through OSB membership, ORS 9.080. The OSB is a private entity created by statute in 1935 that regulates bar licensure under Supreme Court oversight. The Supreme Court itself is composed of bar members. No provision in Article 7 delegates judicial control to the OSB, yet all judges must be bar members, excluding all non-members from judicial eligibility. Number 3. Legal argument. A. No constitutional provisions authorizes bar control. The Oregon Constitution vests judicial power in courts created by the people, Article 7, Section 1. It is silent on bar membership. The Federalist Papers, number 78, Hamilton, affirm that judicial power derives from the people via constitutional design, not private associations. Number 51, Madison, insists on separation of powers, rejecting monopolies over the branches. It is to be noted that no organic state constitution, including Oregon, grants a private bar association judicial authority. Statutory impositions are therefore extra-constitutional. Additionally, If there was a state constitution that allowed for the bar to have control of the judiciary, it would then be in conflict with the federal national constitution and therefore void ab initio. The bar control of the judicial branch is a secret society overreach, absent constitutional sanctions. It is implied in the Constitution of Oregon that judicial powers belong to the people. It is the people that created the Constitution, not private entities. Therefore, no private entity can have claim over the judicial branch, even by statute. Oregon's Article 7 lacks any delegation to the OSB regarding bar control, unconstitutional. Let me restate that, rendering bar control unconstitutional. B. Statutory mandates cannot supersede the Constitution. ORS 2.020, 2.540, and 3.050 mandates bar membership via licensure, but federal number 78 holds that laws repugnant to the Constitution are void. This is also stated in Marbury versus Madison. Statutes cannot override constitutional silence. Such statutes are therefore color of law, lacking root in Oregon's Article 7. The Anti-Federalist Papers, number 11, Brutus, warns legislative overreach creates aristocratic rule. Oregon's statutory bar requirements exceeds legislative power by ceding control to a private entity. This reinforces that constitutional supremacy, federal and state, trumps statutory innovation. ORS cannot lawfully impose bar control absent constitutional amendment by the people. C. Bar control creates a private monopoly and tyranny. Requiring all judges to be OSB members establishes a monopoly that ultimately ties the bar to private British origins, not public will. The bar is a tyrannical secret society dominion intentionally subverting public courts. Anti-Federalist Paper number 11 warns of an aristocracy judiciary detached from the people. Oregon's bar exclusively mirrors this warning, limiting judicial candidates to a private group. Elections, Article 7, Section 1, offer oversight, but only within bar-approved pools. There is a loss of public integrity. This transforms courts into private bar courts, structurally public, functionally private, lacking true people's oversight as the OSB gates access to the courts. Number 4, conclusion. All Oregon courts under bar control are unconstitutional private bar courts. The Oregon Constitution, Article 7, vests judicial power in the people, not the OSB. Statutory mandates, or S's, cannot supersede this, as per Federalist number 78. The bar monopoly, per Anti-Federalist number 11 and other lawful sources, acts as a judicial tyranny by excluding non-members and reducing public oversight to a controlled choice. I am a researcher at law and hereby attest to and give testimony of this brief as of 8th of April 2025. I testify under the witness of Yahuwah, the Elohim Most High, as to the truth of all that I say herein under the penalty of lying. Submitted by Gary Dean of the House of Darby, dated April 8th, 2025.
Anthony Devine. We are our sheriffs. Our Article 3, Amendment 7, Civilian Court of Law, Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system. Rather than ticketing them or supporting the illegitimate amended Article 7 courts, our sheriffs seem to be avoiding any engagement with us. The people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. We are our sheriffs. It is significant that they take a proper oath to the Constitution circa 1859 with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator that is with God included. Such a declaration and oath is needed for there to be remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make it different, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so. I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I fought. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, shot him 3 more times.